Here's a common scenario: single parent with one adult child, one house, one kid, one bank account, and some retirement. It's a fairly straightforward set of facts. All they know is they want their kid to get everything, but they're not sure how to set this up. Let's talk about some common options. Story time. Greta is 50 years old. She's divorced and has one child, Taylor, who's 20 years old. Greta swears she's never getting married again. She's never done estate planning before. She has a house with a mortgage, a few bank accounts, and some retirement from her employer, a 401k. Her big priority? Making sure her child gets the house when she can't live there anymore. Let's discuss a basic estate plan. This would include a simple will giving everything to Taylor. Bear in mind, the state of Washington has a law in the books that gives Taylor everything anyway. But the benefit of a will is that Greta can give him some extras that would help make the process go a little bit smoother. She'd also have powers of attorney, naming Taylor as her decision maker. Her retirement accounts probably have a beneficiary designation form already, naming Taylor as the recipient. This is a simple and inexpensive plan and works for a lot of folks, especially when their child is responsible, and they know it. What about a trust? Greta's heard about these. If she wanted more customization, more rules in place, more conditions before Taylor takes assets, yes, she can create a trust spelling this all out. For example, maybe someone else, the trustee, is in charge until Taylor turns 30 years old. Maybe Taylor has some addiction problems, and she can create a trust where another individual decides when and if Taylor gets funds. This requires the appointment of a trustee, and if this isn't a very large estate, it means professionals are too costly, and a family member or friend would need to agree to serve. This could strain relationships, and there are plenty of videos about beneficiaries having various experiences with this. Trusts can be testamentary, meaning written in the will, or standalone, such as a revocable living trust. If Greta simply wanted Taylor to reach a certain age, a trustee with direction could manage the house until Taylor could do this on his own. This does create more expense, though. Let's talk a little bit about probate avoidance tools. This may be a concern of some people, though it doesn't necessarily need to be. Probate provides some real benefits, and it's fairly simplified in Washington state. It's a factor, but it needs to be weighed in. Using non-probate transfer methods, the house could be transferred to Taylor via a transfer on death deed. The bank accounts have the same thing potentially. Those are called Totten Trusts, or transfer on death forms. There are some drawbacks here too, and sometimes these are only safe on deathbed type planning where there's a greater chance nothing in their lives will change. Greta refinanced her house when she got divorced. She got an awesome 3.2% interest rate. She wants to know if Taylor can keep it. Should he just keep paying it? Well, fortunately, there's the Garn-St. Germain Act. It allows lawful heirs, spouses, children, etc. to take over the same mortgage and stay in the home. Each bank has its own process to transfer the mortgage. Be careful, though, and don't let this mortgage go delinquent or otherwise violate the terms of the mortgage, like maybe turning it into a full-on rental if you got finances for it being owner-occupied. What if Greta wants to qualify for Medicaid long-term benefits and still have her child take the house? She needs to consult with an experienced elder law attorney. This is very technical, and she shouldn't wait because there is a 5-year look-back period. A Medicaid Asset Protection Trust is an irrevocable trust, meaning you can't really change it, at least not very easily, if at all. Also, you can't have your house in a revocable living trust in Washington state for this to work. Greta should evaluate her priorities. Maybe she still wants Taylor to have the house, period. Or maybe she's toured the options and she's not liking the Medicaid ones. She should really talk to someone and evaluate her options. Greta has heard that Washington state has a high estate tax. She'd be right. But before stressing out about this, she should see if she even has a taxable estate. If she's in Seattle, it's not hard to get over that line. At $2.193 million, that's the exemption amount for 2025. If she's close or slightly over, she should evaluate various strategies. Some of these could be fairly simple, like give more to Taylor during lifetime, or simply enjoy life now, such as going on a worldwide cruise with Taylor and his future family. Surprise! Greta got remarried. stranger things happen. It's vital that she update her estate planning documents and coordinate with her new spouse or partner. Spouses have rights by law. She may want to write a new will that gives her new hubby a life estate in the house so that he can continue to live there until he goes into care himself. They should consider a prenuptial agreement, which is prepared before marriage, or, if they didn't get around to it, a postnuptial agreement, which specifies the same things, and also specifies what happens to the house if Greta passes before Carl. One size does not fit all. If you're watching a video from another attorney or financial planner who tells you, hey, this is a no-brainer, this is what you need to do, always, well, that's concerning. Do you use a hammer to repair every broken item in your home? No, you need different tools to solve different problems, and your life usually doesn't stay the same. As per usual, consult with an attorney in your jurisdiction for advice specific to your situation. Thank you for watching this presentation of One Kid, One House, One Bank, What Do I Do? Let us know if we can help.